And he's been working more recently with the International Trade Commission, developing a guide for practice there. So he has unprecedented expertise in the court side, in the ITC side, and this fall he's going to go join the Patent and Trademark Office. So Peter is really uniquely positioned to bring together all of the different branches here for this conference, and we are delighted to have him here to run it. Thank you.
Good morning, everyone. This is, in some ways, a dream come true for me. I, as an economist, try to think about how systems work, how institutions work. And one of the things that I've watched over the last decade or so is how the patent system has really, in some ways, outgrown at least the model that that we grew up with. That the patent office issues patents and courts adjudicate enforcement decisions. But one of the things that happened in Silicon Valley about 20 years ago is the software industry discovered patents. And I think for many years, those of us who were studying this were a bit concerned that this could break out into all kinds of complications. And it didn't really break out too seriously until the dot-com bubble. Some of you will remember that. And there was a big run-up of patenting. And then as the bubble burst, we saw this reaction. We saw the enforcement of patents all over the country, and then more recently we've seen the ITC brought into this system as well, and now it's global. We're watching patents all over the world in a very complex and I think somewhat pathological state. You know, it keeps all of us busy. It's very good for my students. They can get jobs because the system isn't working so smoothly, but it is, I think, one of these classic situations where we have an extremely complex institution, or we have an extremely complex goal, which is to promote innovation through the grant of these kinds of rights, but then it kind of works into all of these different institutions. They each have their own missions. Over the past few years, I've had the opportunity to work with the federal courts, with the ITC, to some extent with people at the Patent Office, and what I see is that they're all trying to solve these problems, but getting them to coordinate and to communicate is something that I think has been lacking. I think there's a lot greater coordination than there's ever been, but this conference, this event, is really trying to identify ways in which we can improve the overall system through better communication and coordination. So just to kind of put this into maybe a broader and clearer perspective for those of you who have sort of knowledge of some parts of the elephant, but maybe not the entirety of it, we can think of the patent system as this sort of production function. We are considering literally hundreds of thousands of applications each year through an examination system. It produces patents of some degree of quality, but not perfect quality, because as Mark Lemley famously described in 1999, it's rational for the patent office not to get perfect results, that it would cost way too many resources, and the information is too hard to come by. And so we rely heavily on the district courts to deal with the most important cases, the patents that are really affecting commerce, and then they are reviewed by the Federal Circuit. But when we think about specialization within the system, the federal district courts, I'll give you a statistic that there's only a few judges, maybe 2 or 3, that ever really did patent work prior to being on the federal district bench. It's just the reality of how judges are appointed. Now, one of the things that's going on, Judge Fogel can talk about this later today, is that we have a patent pilot program which is trying to bring more specialization within the federal court system. And that's, I think, going to help to improve. We're going to have judges who are better prepared. But still, the federal district courts play a critical role in trying to improve both the quality and the application of the patent system. And then they are, again, reviewed by the Federal Circuit, and we have with us today Judge O'Malley from the Federal Circuit, and they're in a very tight situation because and it's not represented here, but the Supreme Court has become very active in the patent system. And for anyone watching the news this morning, you might have seen that the Supreme Court has granted review in the Ultramershal case. They've sent it back to the Federal Circuit. And so that's creating a lot more stress on the system. About 5 years ago, the ITC became one of the key players in the system. Even before the eBay case, the ITC was seeing a lot of patent cases, but since eBay, that has grown quite importantly. So we've got tremendous growth in the amount of patenting activity. We've got this market emerging for patent resolution, patent dispute resolution. So we can think of the district courts as an important part of that market. We can think of the International Trade Commission. The Patent Office is now part of the dispute resolution process. One of the key features of the American Invents Act is to put the Patent Office into a more significant role in re-examination and post-grant review. And the hope is that they can relieve and perhaps better handle some of those technical disputes. We also have sort of a cottage industry of dispute resolution services. And one of the panels that you'll hear from today, the fourth panel of today, is going to look at, among other issues, the international market. Patents are global, and we're seeing enforcement throughout the world. So Mark Lemley did a great article recently where he looks at the factors in selecting tribunals. And he was focusing on district courts, but one of the things that, if you look at sort of all the things that lawyers are considering, success rate, speed, specialization, availability of rule packages, joinder, severance, all of these issues which are in flux right now, the ITC is becoming very attractive for some of the most high-profile cases. So being able to coordinate the ITC and the district court, that's going to be very important as we go forward. Even among the district courts, there's this tremendous market phenomenon going on. Eastern Texas, the District of Delaware, Northern District of California, and now we've got about a dozen pilot districts that are going to be moving this process along. Mark's study, which is really quite interesting, showed that there are some perhaps predictable winners in the race, but there are a bunch of districts, including the Middle District of Florida, which seem to have appeal. And so this is, I think, important for everyone in the system to realize. Let me just say these slides will be available on our conference website. But we're dealing with unbelievable complexity. The very best lawyers are on top of this game. It's really three-dimensional chess. And the companies are having to strategize over where to put their resources. Damage awards are a big factor, where cases are filed. The ITC doesn't have many cases, but they have the most trials of any tribunal in the country. So the PTO is now entering the game. One of the people we have with us today is Remy Usul. Remy is the head of the Central Reexamination Unit. And now that is a very popular venue for defendants seeking another view of patent validity. And we'll get into all these issues over the course of the day. But with that background, what I want to do is introduce really one of the central figures in our patent system, and that's David Kappos. David has a remarkable career. I'll mention this, but don't read too much in it. He did go to the University of California at Berkeley, something that people at Berkeley take great pride in. I'll note that I'm wearing a red, blue, and gold tie. I'm really agnostic about any of these issues. But after, with an engineering background, David went into the patent world, ultimately at IBM, where he was the head of patents. IBM was, and I think still is, the leading patent acquiring company in the world. And he got to watch this story unfold. He was appointed Undersecretary of Commerce and Director of the Patent Office in the Obama administration, has been, I think, the most catalytic figure in the patent system in my lifetime. He has reached out to all of the communities. He has really sought input from all sides and is, I think, aware that the patent system is undergoing its most dramatic changes, perhaps in modern history, and he's doing everything possible to try to bring better information and coordination into that process. So let me turn things over to David.
Peter, thank you very much. Good morning. I will second Peter's comment that this conference is a dream come true, although for me, sometimes I aim a little lower. Anytime I can participate in something outside of Washington, D.C. these days, it's a dream come true for me. So look, first of all, thank you very much to Peter and Mark and all the distinguished jurists who are here today participating in this event. It really is, for us at the USPTO, a really big deal to be able to spend time with the brightest academics in the field, with members of the judiciary that we interact with so much and that have such an impact on our agency and who we are charged with helping, spend some time with them, learning how we can help better, and with everybody here today, with whom I hope we'll have a great discussion during the day, get a chance to learn what we can do better at the USPTO more of and things we can stop doing in order to help the whole intellectual property system work more effectively. So look, my job this morning is a little bit of a scene setter, and I think to start setting that scene and not to be outdone by Peter's animation, I wanted to start, if the team can cue this up, with a brief animation of our own coming from USPTO.
Good morning, Council.
Wow. Stanford is a beautiful campus.
And I thought the Waldorf Astoria was nice.
It looks like a full agenda today.
I think everyone wants to hear about ways the USPTO interacts with the courts.
Yes, particularly how that relationship is changing with the America Invents Act.
Very interesting.
I can tell you about the AIA post-grant review proceedings that are being implemented, but we'll try not to steal the thunder of the upcoming panels.
Tell me more.
Well, the post-grant review proceedings include derivation, post-grant review.
Whoa, hold on there. Did you go to Berkeley? You said post-grant review includes post-grant review. What are you talking about?
Post-grant review is the umbrella term for the 4 administrative trials in the AIA. There's post-grant review, derivation, covered business methods, and inter-parties review.
I see. But wait a minute. The USPTO already has inter-parties re-examination.
That is true, but the AIA inter-parties review will replace the current inter-parties re-examination practice.
Okay, is there anything else?
There are also rules that cover all of the administrative trials, such as technological invention definition, a practice guide, and umbrella rules.
I see. So there's umbrella rules. For the umbrella rules, this makes perfect sense to me now.
The AIA also has a number of judicial provisions, but let's save that for later. What's that you're working on?
Ugh. This is a response in a patent litigation case with over 3,000 pages.
That is ridiculous. That is more pages than the proposed trial rules combined.
The courts may benefit from the USPTO's page limits on briefs. Maybe we could get a couple provisions enacted.
Good luck with that. It only took 8 years to get post-grant review enacted.
8 years. OMG. Let's get back to the agenda.
Okay. Thanks to the PTO team for putting that together. Well, look, the point is that the AIA has given us all an enormous opportunity. We really reset the table for the United States in a way that hasn't happened in many, many generations, giving us the opportunity to have the world's first and only truly 21st century patent system. But as you can see from that video short, put it mildly, it's complicated. There's a lot of work to be done. And while we have an opportunity to put together a great system, like most of life, like most of management, now it's all about the execution of many, many processes, and that's what we're working on right now at the USPTO. So what I'll do for a few minutes is talk about some of the things going on under AIA, and then also set the scene a little bit with some of the more general process reengineering improvements that we're working on at PTO to kind of get us ready for our first panel here this morning. So AIA, of course, you start with the litigation-related impacts, and you can already see a couple of important positive changes that have occurred, parts of the legislation that were actually put in force immediately after the legislation was enacted. For instance, the change in key TAM actions for false marking, which has largely gone away now suddenly. Positive impact of the AIA, and I think you can check that one off. I think also the instances of joinder and venue-related issues that were affected by the AIA have significantly improved with, if you set aside the short period in September when the legislation was about to go into force, significant improvement brought on by the AIA in the area of joinder of parties. So some early provisions, early successes there. And that brings you then to something that we'll talk about a lot today, which is the so-called contested provisions. So we're talking about the provisions that go into effect a few months from now, September 16th, 2012. And this is inter partes review and what I'll call post-grant opposition, right? And the changes to, supplemental examination, the covered business method review, supplemental examination which reads its way into ex parte reexamination. All very heavyweight processes, all of which we're in the process of writing final rules on now. Remember, we put out notices of proposed rulemaking. We got tremendous comments, including probably from a lot of people in this room. We're now reworking all of those, and we'll be coming out with the final rules, I hope, before the middle of August. I say I hope because I'd like to come out with them in July if we can, giving extra time for us to all educate one another before those rules go into effect on September 16th, 2012, and I promise you they will go into effect on September 16th, 2012. Now, the great thing about those proceedings, if we can get them right, is speed and accuracy, right? We are doubling the size of our Board of Appeals and Patent Interferences. We've got our Chief Judge, James Smith, and his team is out hiring very, very actively right now, trying to go from about 100 judges to about 200 judges. We're having tremendous success attracting really, really strongly qualified folks, many former Federal Circuit clerks, former district court clerks, partners from law firms, people from all over the country who want to come and be ALJs and work on these processes. Now, why is that so important? Well, two things. One, we got to get on top of the backlog of unexamined appeals. And we'll get to this stuff later today, too, because anything that's undone at the USPTO represents an overhang in the marketplace. And while you don't want applications to go unexamined, one thing that's even worse than that is for post-grant processes, including appeals, to be taking too long, because those are the most important patents. You've got to get them resolved quickly, and you've got to get them resolved accurately. So more judges will help a lot with both of those. We'll use those judges to get on top of that appeals backlog. We'll have those judges in place come September 16th to be ready to take the incoming work that you're going to be sending under all of these post-grant processes, and we will meet our mandate of processing those post-grant cases in 1 year. Remember, the statute says 1 year with an ability to extend for 6 months if needed. What I've told the team at the PTO is it's 1 year, right? We're not extending these things. We are going to get them done on time. That is the only way we provide real value to the district courts, to the ITC, ultimately to the Federal Circuit, and especially to those of you in this room who are looking for fast resolution of matters that you're bringing in front of our agency. So we're very, very focused on speed, accuracy, and rules that will enable us to do both of those things very, very competently for you. So that's the post-grant provisions. Now, that brings you to some other things that are involved in AIA that are also about speed and accuracy, and I'll just tick them off really briefly here. Remember, AIA put in place, for the first time, the mandate for the USPTO to process patent applications in 1 year from start to finish, right? That was what we call the Track 1 proceeding. We put it in place 10 days after the implementation was enacted, and we had predictions on both sides of the aisle. One of them was, oh my God, you're going to be overwhelmed. There'll be 10,000 post-grants filed on the first, or 10,000 Track 1s filed on the first day, and you'll never be able to keep up. And then the other prediction was, well, this is going to be like a dull thud. Nobody's going to care about this. Nobody will file these things. And why are you guys even bothering with it? I'm happy to say neither of those two extremes has come to pass. And indeed, we're going on so far about 4,000, almost 4,000 Track 1 applications filed. We are getting a first office action out right on the 3-month mark, which is exactly what Congress asked us to do. And we haven't come up on the 1-year point yet, but we are well on our way to processing those cases to completion in under a year total elapsed time. In fact, we've put out many patents so far, like I think 350 or so notices of allowance and several thousand office actions. So it's safe to say that if you want speed out of the USPTO, you can now get it. It's the process called Track 1. It was actually invented here in the Valley, in fact, right here at Stanford University. It was a suggestion made right here, and all we did was go and implement it. Now, one other question people ask, the question I'm constantly bringing up, is what about quality? Because speed without quality is disastrous for the system, but especially for market players here in this area. Well, we measure our examiners under Track 1 by the same quality requirements as for everything else. I believe that the reason Track 1 is going so fast and the reason it's got a high allowance rate is not because of any quality problem, but because applicants are submitting really concise, well-written applications. They're engaging with our examiners aggressively. They're getting through the process promptly. They're putting in reasonable claims, and they're getting out reasonable claims, and they're showing how, when you engage, the system really can work effectively. So that's Track 1. I hope you'll watch that closely. The statistics are all reported on our website. And talking about Track 1 enables me to transition quickly to the second of the 3 topics that I want to talk about here in my short time, which is quality. So if there's anything that I came to the USPTO to work on, it was quality from the very beginning. Coming from the IT sector, I realized, like many people in this room do, that that we have been challenged from time to time relative to getting things right quality-wise, and it's a byproduct of a lot of issues, not the least of which being that the laws are constantly changing, that we're operating with technology that's constantly moving, that we've got a lot of smart professionals trying to make a lot of hard judgment calls all at once. So how do you manage in a system like this? Well, you put in place much better quality controls and much better metrics. And so we did that in consultation with this community, with our Patent Public Advisory Committee, a couple of whose members are in the room with us here today. And we went at the USPTO from tracking 2 objective measures of quality to tracking 7 objective measures of quality. So we now measure more about quality at our agency and the output of our office than any other patent office on the planet by a wide margin. And the answer is, what we're finding is, when you give people more time to examine patent applications, no surprise, the quality goes up. So we did that. We gave examiners more time across the board, and we weren't surprised to find that our quality took a step function increase. And then we started doing some other things at the agency. Another idea that came right here in the Valley, which was, why don't you put out real guidance for your examiners to finally start examining applications very, very carefully under Section 112. Sufficiency of the specification, correspondence of the claims to the specification, right? I'm talking 112.1, 112.2, 112.6 for the real nerds in the audience here that are following those sections of the statute. And so sure enough, we put together, for the first time ever in the USPTO, and the solicitor right here in this room led in doing this, guidelines for our examiners under 35 U.S.C. 112. And about a year ago, we put those guidelines into place, launched them, gave training to every one of our 7,000 examiners, and started measuring our uptake under those new guidelines? Well, we recently benchmarked, now that we have nearly a year of data, and I hope we can talk about this more during the discussions today, but we're quite pleased to see that indeed 112 rejections have gone up over the last year. If you've seen more engagement with examiners on 112 issues, well, that's why. I hope you consider it to be a good thing. But interestingly, when you dissect any trend at the USPTO, you find out again it's complicated, because at the same time that examiners are being trained and are pushing 112 issues harder, they're also engaging more with applicants, doing many more interviews than they have in the past. In fact, tens of thousands of hours more interviews than we've ever done before. And what happens when examiners do interviews is that they talk about 112 issues, and applicants are able to correct 112 issues without examiners having to interpose objections and rejections. So we've got counter trends working against one another here. At the end of the day, I believe it's all fine, because what you get is a clearer patent coming out, and whether you had a 112 rejection or not, or the claim term was just changed in an applicant voluntary amendment, to me is not such a big deal in terms of file history clarity. What's key about the claims and their correspondence to the specification is terms are defined, terms are clear, there's specification support for 112.6 issues, stuff like that. Clearly are making a lot of progress in that regard, and I think it's fair to say that those 112 guidelines are significantly to credit for it. So, and that brings us to the subject of interviews more generally. So one of the big things that we've worked on at USPTO, beyond just the legislation, is increasing the efficiency with which we engage with applicants to get more work moving through the agency more efficiently. And it's true. We have not only granted record numbers of patents the last 2 years, we've also had record numbers of final rejections the last 2 years. In fact, last year I think we granted about 320,000 patents, and we issued about 330,000 final rejections. So clearly just more work moving through the agency in all characteristics. Well, why is that? It's for several reasons, one of them being compact prosecution. Training, incenting examiners through a new performance system, through new measurement systems, new count or credit systems that send a message to our examiners that we want you to understand the application by spending more time on it on the front end, and then engaging very aggressively with the applicant, aggressively meaning not aggressively to say yes or no per se, but aggressively to get to the issues, not push paper, but understand what the invention is about, engage on the merits of the invention, help figure out if there's patentable subject matter, get it through the office if there is, and honestly reject it if there isn't, so that the applicant can go to appeal or abandon the case, but just get through with the process one way or another. And we call that compact prosecution, and it really works, right? If you get people, just like any other work that you do in this room, if you understand the subject matter the first time through, engage it aggressively, you can get your work done without having to repeat it and push paper constantly. So all of these initiatives have been about aggressive engagement the first time through, understanding the case, and coming to a disposition that the applicant will either agree with or agree to disagree with, but one way or another getting done. And part of that has been much accelerated use of interview practice. And I hope many of you have noticed this. We, several years ago, we were at about 97,000 hours of interviews annually. A couple years ago, we got that up to something like 130,000 hours, then up to 140,000 hours. This year, we're on a trajectory to hit 170,000 hours of interviews. And I actually think that's a great thing, provided that interviews are properly conducted and recorded, right? Because another thing you don't want, and I've seen this before, I've been on the defensive end of these lawsuits, probably some of the judges in this room have seen them too, is first action rejection, final action rejection, RCE, first action rejection, interview, followed by notice of allowance with no amendments in the claims, and an interview summary that says, after the interview it was decided the case was allowable. That's not a good thing, right? We don't want that. We've given extensive training to our examiners regarding conducting interviews but then appropriately capturing and summarizing the content of the interview so that the applicant is okay with it. The examiner is able to reduce to the record exactly why a change in heart was had, why a different decision was made. And if you conduct interviews that way and capture the results that way, you get something really great at the USPTO, which is you get away from the ships passing in the night syndrome and the churning of cases and the RCEs and the inability to actually get through with work, and you actually get an understanding of what the applicant invented, and you get the ability to work with the applicant, come to a conclusion effectively. So all of that is about a management system that rewards and incents and puts the tools and the training in place to work efficiently and effectively toward resolutions that are high quality and that get the patents out that should be gotten out and that get those that shouldn't be gotten out to a state where we're done with them one way or another. Now, that gets me to the last thing that I wanted to talk about, which is the area of the other kind of changes that we're working on, and that gets into information technology, something that shouldn't be strange at all to most people here. And lastly, what I'll say on that is it starts with third-party submissions of prior art. Right, some of you have heard of the peer-to-patent pilots that we conducted several years ago. Well, those have concluded. We now have under the AIA the ability for third parties to submit prior art with commentary to the USPTO starting September 16th of this year in every single patent application that we're examining. So there's a lot of interesting nuances here. Query how that works with Track 1. Well, it doesn't really work with Track 1 because those cases get issued before they get published. So we've got a little bit of a challenge there, right? It's, think of maybe an opportunity for some future legislation or incentives in that regard. But for the main body of cases that publish at 18 months and that get examined after 18 months, we now have a huge opportunity for third-party comments. We already have the IT work underway. You've seen the rules that we've written. I have held firm on the notion that for 3 submissions submitted electronically, there won't be any charge for them. So we're trying to make as low friction a system as we can. But we're also working on putting together much more high-function IT-based capability that will enable people to collaborate on looking at prior art, commenting on it together, refining comments, and then pushing that magic button that routes the art to the examiner with the application so we can use modern information technology, think the internet meets the USPTO, to do a much better job of harnessing public input in that fraction of cases where people actually care and there's prior art that won't otherwise come to the examiner's attention that we need to look at. So information technology, very much to the rescue. We very much have that in mind. And that cascades into the last point, which is, even if you do all those other things that I've talked about, if you do them on the PTO's old IT infrastructure, you've got serious problems. So we started an effort now, over 2 years ago, 2.5 years ago, to totally remake the USPTO's IT systems. It's called Patents End-to-End. It's well underway. In fact, our central reexamination unit, which Remy Ucel is here representing, is already partially working on the actual code for Patents End-to-End. This is not a prototype, it's the real thing. We're in the process of rolling the CRU over onto it. Later this year, we'll begin rolling the entire patents core over onto a single cloud-based application that enables examiners to have at their fingertips for every case they're looking at, diagram of the claim tree, simultaneous view of the drawings, the specification, the claims, automatically relating the claims to like terms in the specification, automatically doing background searches to pull up prior art and get the examiner started on looking at the art. All of the things you would expect from a basically decent late 20th century information technology system. We're working hard to finally put them in place at the USPTO, and Remy can comment on this more later, but I'll tell you, we are making progress. We are on our game to get that done. So that's just a little overview. AIA, big opportunity, major implementation challenges. big capability for us to do a better job for the courts and work better with the courts at the USPTO. Lots of operational moves in order to try and just do a better job underneath the AIA, and an information technology system that buttresses all of that. And you could actually have a 21st century patent agency here before too long. Peter, thank you very much.
David,
Oh.
well, thanks, but what I wanted to do this is part of a day-long exercise in which we hope not just to present, but to engage. We've got some time for some questions, and I think anyone who's got a burning question to the Director of the Patent Office, please.
And I may invite my colleagues Remy Ussel and Ray Chen and John Quebeca to help also. But so questions, comments, things you're seeing, things that you want to talk about? Mark?
So you mentioned issue with 18-month publication and the expedited examinations. Is there any reason in the law the PTO couldn't require early publication as a condition of getting into the expedited?
Yeah, Mark, that's exactly one of the things that I'm thinking about doing, and I don't see a reason why we couldn't. It's a voluntary program, and we can say as a condition of entry into this program, you've got to permit 3-month publication so that people can comment. So that may be a change that we make down the road to track 1, yeah. Oh, a lot of questions. Sir?
One of the best repositories of prior art has got to be the Patent Office's own files, the file records, and years of submissions by people over time. What is the PTO doing to increase access to that?
Yes, great question. And indeed, we have millions and millions and millions of records in our back file. So, several things. We are in the process of digitizing 55 million records right now in the that's just the active back file. That means applications that are pending in some form in the agency. After we get done with that, we got to see, subject to resources, how we can go back further in time and capture all of that prior art that you guys have been submitting for hundreds of years in every single application, and get that in a text form that we can use it for searching. So we are committed to doing as much of that as we possibly can, starting with the back file. We now finally have the XML infrastructure set up to begin permitting and incenting, and eventually kind of requiring, XML submission of new applications, so that we don't have to keep converting things all the time, right? Now, I don't know that we're going to be able to get applicants to submit the prior art in XML form unless you happen to have it in that form. So we'll be winding up taking submissions, at least for the foreseeable future, as images the way we do now, which means we've got to do the scanning and OCRing and converting to XML. But we are committed to doing that so that in the future, every prior art document you submit in every application becomes full text available to every examiner at the agency in every subsequent application that we're looking at. We got to get to that. So we're on a path to do exactly that. It's not at all impossible. It's in our budgeting plan going forward. The thing we'll have to figure out is how far we go back, because you're in the end, you're talking many, many hundreds of millions of documents. So yes, the one thing we can't do, though, is make that file available to the public, because you get into serious copyright issues when you do that. So it'll be available to examiners for conducting searching internally, but we're not going to be able to make that huge file available to the public. Great question. Barney?
2 questions. One, how well is Silicon Valley doing in the contest to host a satellite office?
It didn't take long to get to that question.
And 2, how hard should the members of the patent community fight for permanent funding for the patent office from fees? Or is this something now that you're confident you can get on a year-to-year basis and negotiating with the Congress?
Yeah,
or
yeah.
is it something we should really be fighting for nonetheless?
Yeah, thanks, Barney. So relative to the first question, we opened Detroit in less than 2 months, on schedule, on budget, looking really good. We've already hired board judges, examiners. We're going to soft launch early because we're ready. It looks really, really good. We're in the process of choosing at least 2 more offices. I expect to have a decision this summer. Many, many great cities across the U.S. put in requests. It should not, and look, I'm a native Californian, okay? My entire family's in this state. I lived in this valley for 10 years. It's not going to break my heart for the USPTO to be opening up a presence in California. It would not surprise you at all to know that the Valley is a very strong candidate, has many, many great things going for it, including a huge IP community. It is challenged in one category, which is the cost of living, including housing prices, but that's something that, that we can work our way through. So decision this summer, Barney, and we'll, you'll be the second one to know. Okay. Other questions?
What about the funding?
Oh, sorry, I'm sorry, I didn't, I'll finish that and then go to the gentleman over there. Yeah, funding. So this year, we have been fortunate that Congress gave us access to all the money that USPTO collected. And let me tell you something, it has been transformative to the agency. In my first 2 years at the PTO, I spent an enormous disproportionate amount of time, at some points the majority of my time, just fighting to get access to the money you were paying in for us to do our job. Extremely disruptive, extremely negative kind of way to have to work, and very, very hard, and creating a lot of strife and tension inside the government. Now, that was then, this is now. Since AIA, Congress has given us all the money we collected this year. It has been transformative, zero time fighting about money. We are just running the USPTO, running our place, doing the things that you would expect us to be doing, right, implementing this legislation. So it's been a huge relief. And our relationships on the Hill and with OMB and others in the administration have improved immeasurably because now we can just work with them on substance. Congress has also recommended an appropriation through all of our committees so far in the legislation that's now pending to appropriate to USPTO this next year, again, all the money we collect. So that'll mean no fee diversion. So if things keep going like they're looking, we'll go 2 years in a row with access to all the fees we collect. That's a very, very good thing. But to finish the answer to the question, I think this is like anything else that is in the nature of a gentle person's bargain, if you will, that continued vigilance is needed. The IP community, the innovation community, everybody in this room needs to keep a close eye and continue advocating to ensure that all the funds that you pay into this agency for us to do your work stay with the agency. I would not recommend that anyone, quote, let their guard down, because the deal is basically year by year, which means we've got to keep it and keep the heat on it year by year. Thanks, Barney. So one other question over there?
You mentioned speed and accuracy in PTO. Professor Manel talked about the litigation process. More specifically, how are we getting control of the costs? Costs to the applicants in using the patent system, costs to the litigants in using the litigation system. Both have exploded over the last 3 years. Very hard to get a handle on. Clients obviously are concerned about that, as are everybody in the process. So there's been specific look at what all of this costs.
Yeah, great question. Cost, the U.S. Has historically had and still has the bargain of the planet in terms of patent systems with fees that are far lower than any other major patent system by a fairly wide margin. That continues under the AIA. Now, it's a complicated question, and I can only answer it partly because a lot of it involves litigation. We'll talk about that in the context of panels today. But what I will say is that the USPTO has recommended fee changes as part of our implementation of the AIA. We put out a first draft in February. It was very much a first draft. Our Patent Public Advisory Committee is currently preparing recommendations for us, which we'll take into account as we move into the rulemaking process. We're very acutely aware that any increases that we make in the fees that we charge have an impact on our community and ultimately an impact on American and global innovation. We've taken into account the many comments that we've got. In fact, I edited on the airplane on the way out here a 100-page document that takes into account, and we're still pending recommendations from our PPAC, and recommends many, many changes to our fees exactly because of the issue that you're raising. Trying to moderate, in fact, trying to provide paths through our system that will actually net reduce your fees from what they are pre-AIA for the majority of applications, and even appeals. So we're trying to moderate fees to make sure that while we need to raise them in many places to fund the improvements that you want us to make to the agency, that we're making those changes in as reasonable, targeted a way as we can, and providing more options and more paths through the system so that you can make cost-effective choices. Now, the last comment I'll make on costs is that those post-grant processes, which are expensive and will remain expensive, Congress directed us in the AIA to set those fees, right, based on the cost of implementing the work. It was unique language that was included in the statute for the post-grant provisions, but not for other provisions. So I do not feel empowered to just set the cost for those post-grant processes artificially low. I do feel like we've got the leeway to not tie them numerically or mechanically to the cost to perform the services, but we need to have them some way rationally related to the cost to perform the services. And when you're talking about 3-judge panels, 3 ALJs, and many, many hours spent on highly contested proceedings, yes, they're going to be expensive. Last comment, though, is when you think about expensive, you also need to think about least cost avoidance, right? And the least cost alternative for those post-grant processes is the ITC or the Article III district courts, which will remain, I think it's fair to say, far more expensive because of all the issues that you get into in dealing with district court and ITC litigation. So, I hope that we'll think about these post-grant processes not just in terms of the $20,000 or $30,000 PTO fee, but in terms of the total cost to get through the process versus the alternatives and the costs associated with them. And my aim is that at PTO we provide very cost-effective alternative.